Well, welcome everybody to the Solid Waste Subcommittee. We're going to get started now, and I guess I'll be clerking as well as chairing. I've already got my outline set up, so it's pretty much going to be a free-for-all. There's only 4 of us, maybe 5 of us today, so you don't need to ask me to call on you to talk. I think anybody who has something to say is welcome to say it. That being said, I guess we'll start with HB171. And I'll hand the reins over to Representative Germana. He's got some stuff to say on that, and we'll discuss it then.
Thank you, Mr. Chair. So I just sent everyone on this subcommittee a copy of some language. Representative Gruber and I have been going back and forth with Director Wimsatt. We very much appreciate his help. At the hearing for that bill, we received some feedback about some tightening of the language that would make it more technically accurate. And so if you're able to find the document I just sent you and open it, you can get an idea of some of the changes that we're looking to make to the language, and they're really very straightforward. You have that, Mr. Chair?
Yeah, I'm pulling it up right now. We'll see if
we have it here. We have it here.
Yeah, I found that oftentimes attachments don't open up in my. I need to take it down to the technical services. So I may need to peek over somebody else's shoulder to look at it because I can't see it on my computer.
So you can see the changes that we're looking at making here in the first paragraph. Again, it's really some technical language changes, right? So the department may accept applications, and one of the things that the director suggested is that we may want to amend the original bill to allow for the review of applications for completeness. That's not getting into the kind of technical specifics of an application, looking at the geology of the site, etc. This would be to make sure that the application is complete. So that way, at the end of the moratorium, you would be, if there is an application, you could begin review of the application because the file would be complete. So we changed the language here, as you can see. The department may accept applications, evaluate them for completeness, and request more information to make an application complete, but shall not proceed to further evaluation or process any application. So that was intended to address that issue. Then you can see that notwithstanding RSA 541, that another good suggestion the director made was that under current statute, if an application is received and it's not acted upon within, I think it's 30 days.
It's basically, once it's complete for a landfill, it would be actually on 180 days.
Okay. But so if it's complete and it's not acted upon within a certain period of time, it's automatically approved. So at the director's suggestion, we added this notwithstanding clause, which means that this becomes an exception to that rule. We removed the word fully in the second paragraph, and again, that just makes it more accurate in terms of the permitting process. And then in paragraph 3, we would be eliminating I'm not sure how or why that reference to perennial water bodies traversing a footprint. I'm not sure why it was there, but at the director's suggestion, we would eliminate that because they wouldn't cite a landfill in a place if you had a perennial water body traversing the footprint of the proposed site.
Okay, so the text in bold that we're seeing on here is removed, or?
Yes, you'll see that will cut, exactly, that starting with perennial water bodies and ending with will cut, that whole bold section has been removed. So yeah, as I said, this does 3 things. Number 1, allows the department to receive applications and evaluate them only for completeness so that they be ready to review when the moratorium ends. Number 2, added the notwithstanding clause. Number 3, got rid of the word fully, and number 4, eliminates the unnecessary language later in the bill.
And one question. one question is, if DES says a application is fully complete. Speaking of that. Oh, yep. If DES says, thank you, it's fully complete, and during the moratorium there's some additional changes, could the applicant say, well, you said it was complete, so you can't require anything more from us now. So the question is, fully complete or towards completion, for example. See what I mean? Any thoughts about that?
That's an excellent question. If we could ask perhaps the director, I think that's an excellent question, because obviously the point of the moratorium is for us to take our time to pass some legislation.
There may be some additional requirements that we don't have initially, so it's my concern.
Good morning. For the record, Mike Limsat, Director of the Waste Division from New Hampshire DES. Yeah, I think that's a very relevant question. I think that, certainly as I was trying to assist the sponsor with language for this, it occurred to me that if changes in policy through law or administrative rule were made during that time, that it would be necessary for the landfill permit applicant to amend the application. So the purpose of the comments that I made were that it can take a very long time to get to a complete application, particularly for a newly sited landfill. And if we were to just simply receive an application and do nothing with it, then basically until the end of the moratorium, which I understand this bill was set in 2030, we would not even have begun that process. So it could be several years after that before complete application an application was deemed complete, and then the application was subject to review and then acted on. And so this would basically just give an opportunity to at least make sure that the things that are clearly missing from an application could be brought in during that moratorium period. But my view would be, and again, I think it would be a question for attorneys, but is that there were policy changes made in that interim period before the application review began, and they were deemed to be applicable to that application, that the applicant would be incumbent on them to augment their application further to make it complete, to comply with those new requirements that didn't exist at the time of the initial application. So.
Yeah, it's just that would be, from my perspective, really, that one sentence would be ideal to be added to here, so that you have more flexibility.
Sure. I guess I would offer it, certainly to be clear, I suppose the bill could be amended to explicitly state that any changes in policy or in law or rule that occurred during that moratorium period would be applicable to any applications that were pending, that had been submitted during the moratorium period, so that it would be clear that the applicant would need to then amend the application further, or augment the application further to comply with those new laws or rules.
Please. Thank you. Let me ask you, is that effectively already the case now? For example, if you had an application that was pending at the time that the new rules were adopted, wouldn't it, at this point already, in order for that permit application to be complete, it would have to meet the new rules? Is that already effectively?
The way that I understand it, it could depend upon the circumstances. It could depend on what particular rule was amended, whether or not that rule would apply, and that's a question that we would engage with the Department of Justice on at the time that it happened. And I'm not sure, and again, I'm not legally trained, so this is my understanding, but my understanding is that it isn't absolutely clear that any rule change that occurs, or even any law change that occurs subsequent to an application being submitted, will automatically be applicable. In many cases, we believe it is, but it's not necessarily an absolute, absolutely the case in every case.
So maybe wording like Representative Gruber suggested might be helpful here, just to clarify that in this case.
That would be my sense, right? If that's the will of the legislature, then stating it explicitly is an effective way to make sure that that's implemented.
Can it be proposed insert at this point? It could read, any changes in policy or rules during this moratorium period would be also applicable
I would offer substitute law for the word policy. So any changes in law would be clearer.
So, two questions for Representative Germana. Are you happy with the language of the amendment you have? Do you feel that it waters down the bill too much? Or are you happy with it? And then it sounds like, my second question, it sounds like there still needs to be potentially another amendment made to further fix this issue of, applicants that apply before the bill takes effect and things like that. Do you intend to make another amendment to address that issue, or do you want to go forward as it is?
Thank you. I am very comfortable with the suggested changes and the inclusion of Representative Gruber's suggestion. And we haven't actually submitted the amendment yet because we've just been talking about the language and haven't had time. And I figured we would talk about it this morning, and this is a good example of why we didn't submit it. So we were planning on today, Representative Gruber is going to submit the amendment. So yeah, I'm comfortable with it, and I think the timing is good. We can get an amendment sent to OLS today.
If that's the case, then do you believe we'd need to meet or have another subcommittee meeting for that, or do you feel confident that once the amendment is done, it could just be brought forward for during executive session, and then given to everybody, briefly reviewed, and then voted on during executive session?
My sense is that we could just take it straight to an executive session. I don't know if Representative Scully has any thoughts or concerns. As long as we have consensus on the subcommittee, I think the amended version can go straight to executive session.
Well, if you're soliciting my opinion on this matter, I personally think that this legislation is ill-advised. However, I think what the amendment you're proposing is a marked improvement on the original legislation itself. So that being said, I would much prefer that this be brought before our committee rather than the original language, legislation itself.
Okay. Well, thank you. Then, if that's the case, I think you're doing a good job with that bill, and you should just continue doing what you're doing, and then we'll bring it before the entire committee. So we'll close HB171 for today. Question for you, Representative Germana. You might know better than I do, but I was given some paperwork here for the clerk to, if we have any motions or anything like that for the subcommittee. Is that necessary? Do we need to do anything with this? I mean, we're not making any motions to OTP or anything like that, at least on this bill, but maybe on another bill if we have if we recommend an OTP, there might be something we vote on, but I think at least for this bill, we don't have to do that.
I don't think so, because the amendment hasn't been worked up yet. I think that we can explain to the committee later that we will have an amendment, that the consensus of the committee is that it can go to executive session.
Okay, great. Well, in that case, we'll be done with HB171 for today, and we'll move over to HB215. You ready to discuss that?
I am, and again, my apologies for not having hard copies. We're having some issues with the photocopier upstairs, but I emailed the HB215 to the members of the subcommittee.
Is that the other one?
Okay, I'm going to pull that up now on my computer. You guys have it there?
Yeah, we have it. Yep.
Okay, and I have it as well if you want to discuss it.
Okay, thank you, Mr. Chair. So again, I want to thank Director Wimsatt. He and I spent quite a bit of time going back and forth on what the language would look like here, and if my colleagues recall, we had some questions about the initial bill that we wanted to get clarified. One has to do with how the independent third party would be contracted, and I'll point out to the specific language that we included to explain that process. And then another question was if we might have the review of possible net benefits as an initial screening stage, right? So that it would be reviewed for possible net benefits first before it would then progress to the kind of review that DES does for looking at the site. So as I walk you through the amendment, and it's taking the original bill and fleshing it out a little bit. So you can see Roman numeral 3, prior to completing its full technical review of an application, the department shall determine whether a proposed solid waste facility provides a net public benefit through an initial process. And here we define net public benefit. Net public benefit exists if potential benefits for a proposed project are determined to be greater than the potential harms. And then you see only if the department determines that a net public benefit exists shall the application proceed for further review. So this sets up that two-stage process. It defines net benefit. You look at A, B, and C from lines 11 to 18 already exist in current statute. Where we have added is language now about how the evaluation will take place. To assist the department in the determination of a net public benefit, an assessment shall be conducted on behalf of the host community and or other abutting municipalities by an independent third-party contractor, and the costs for such assessment shall be borne by the applicant. And this is where Director Wimsatt and I work together to figure out what that process looks like. The applicant shall submit a list of no fewer than 3 independent third-party contracts to the department. The department shall review the qualifications of the contractors, and provided that it finds them qualified, shall work in consultation with the host community and the applicant to select a mutually agreeable contractor.
Which lines are you on?
I'm reading from letter D from 19 to 28.
Line number.
About line number 24. And this is at line 25. If the department determines that one or more of the submitted contractors is not qualified, it shall require the applicant to identify additional contractors. If a mutually agreeable third party has not been identified within 60 days, the commissioner shall choose from the submitted list. So we felt that this was a fair way to choose a contractor. The applicant would submit a list. DES would work with the contractor and the host community to try to find a mutually acceptable third-party contractor. And if that can't happen, if a mutually agreed-upon contractor isn't, arrived at within 60 days, then the commissioner would choose from the list submitted by the applicant.
I have a question. What is the host community? How would that be defined? Are there going to be citizen activist groups, which are not necessarily a bad thing, but is it going to be the elected officials of a town in which it is located? That's obviously open, a broad term and perhaps open to interpretation. What are your thoughts regarding that?
And I think the director can speak to that. Relations with the host community are already defined in statute, so it is a public body that represents the host community, but perhaps the director could provide more clarity.
Yes, typically, anytime we're dealing with a host community, we would anticipate that is the, it's a town or a city, would be the governing body within that town or city, either a board of selectmen or city council, and that they would make, to the extent that that governing body decided to appoint a certain group of citizens, they could certainly do that. But basically, we defer to the governing body of the municipality when we're dealing with a host community.
Thank you.
Thank you. No, excellent question, Representative. So we, as you said, that was came out of a discussion between myself and the director. If you look at line 29, letter E, another I think very productive thing that came out of our discussion was trying to arrive at a fair balance between benefits and potential harm. So our current statute only defines benefit in, well, not only, but primarily in terms of capacity need. Right? And as the director has pointed out in the past, actually members of industry have argued that other things should be considered under potential benefits. So I think that what we've arrived at here is language that really seeks to balance potential harms and potential benefits. Because, you know, contrary to what has been suggested by some, the purpose of this legislation is not to make it impossible to site landfills anywhere. So paragraph E here, in the lines 29 down to 5 on the next page, are really meant to balance potential harms and needs. So you'll see at line 30, potential harms shall include any potentially harmful impacts on human health, property values, tourism, outdoor recreation, and wildlife. Such impacts may include noise, it goes on. But then in line 3, you say potential benefits shall include, in addition to capacity need as described in the previous subparagraph, potential economic benefits to the local area and potential infrastructure improvements associated with the proposed project and other factors as identified by the contractor. So the purpose of fleshing that out is to provide guidance for a more balanced comparison of harms and benefits, rather than one that might lean too far in the direction of simply harms.
A quick question first. Rep. Germana, did you send this amendment email to Representative Potenza?
Yes.
Okay, so Representative Potenza, we're on HB215 right now, and we're discussing an amendment that Rep. Germana has gone over. So it's in your email.
One question, it might be in here, is the doing this assessment is not for off-site benefits like a new MRF and another. Is that right? Is that still in here? The off-site benefits?
Yes, thank you very much. I'm glad you brought that up. That needs to be. Thank you for bringing that to my attention. Actually, that does remain. In fact, I remember putting that in the email to OLS, that what we are looking at is the only part of the bill that would be amended from the introduced version. So the other two components of the bill that have to remain, this would just, if we looked at the original bill, this would just replace this section of the bill. The other two sections remain. Number one, it applies to only one facility, and number two, capacity need is determined by at least 1/2 of the lifespan of the proposed facility.
Okay, thank you, because I wasn't certain, like.
It's a great question.
We'll build a new road through the state to get the trucks in, how far can that road count towards the benefits?
So do I understand it correctly that OLS was supposed to take out a certain part and they didn't? Or are you happy with the amendment as is?
No, they will actually have to add back in some original material.
Okay, so this isn't going to be the final draft of your amendment. You've got more work to do on it.
Well, I just need to have them add back in the original material, but yes, that was, I'm glad Representative Gruber pointed that out, because I did tell them specifically this should substitute for the first part, and then the other two parts of the bill were supposed to remain the same, and they're not included here, so yes, I need to make sure that they put that back in. There are no changes from the introduced bill in those sections.
Does anybody else have any comments on the proposed amendment as is?
If I could, just a couple
Please.
more things to add. So one of the questions that was brought up in the hearing was, how would DES do this? DES has certain expertise. There are other kinds of expertise that they don't have, that they would need to ask for some assistance on, particularly around tourism and impact on infrastructure, et cetera. So again, language that the director and I discussed as hopefully being helpful to DES. This is letter F, line 6 on page 2. To assist in the review of the third-party assessment, the department shall consult as needed with the Department of Transportation to evaluate impacts on local traffic and infrastructure, the Department of Business and Economic Affairs to evaluate impacts on the local economy, and the Department of Natural and Cultural Resources to evaluate impacts on tourism and local natural and cultural resources. And what we didn't want to do was to create some big formal new structure like the Site Evaluation Committee, but to keep this as much as possible within DES. And through the discussions with the director, we came, with his assistance, I came up with this language, which is intended to give DES the ability to consult with other departments to get expertise that they may find helpful.
Quick question for Director Wimsatt. Is that normal behavior for one department director to be or one department to be in communication with other departments in this sort of a way?
Yes, both formally and informally. So certainly there are a number of laws across the New Hampshire statutes that give an individual department a directive to consult with another department head or another department on particular items where they have expertise, and we certainly do that. We also, there's nothing to prevent us from seeking guidance and using taking advantage of the knowledge and the expertise of our other departments. So we do that informally. What this would do, as I read it, is it would, because we're now being given the directive and the authority to evaluate additional concerns relative to siting of a landfill, this would essentially make it clear that in that process of reviewing this report that's envisioned by this bill, that we would be given a directive to say, hey, if you need guidance on these particular topics, go to the experts on it.
Thank you. Representative Germana, do you feel that this language is sufficient in as much as, the Department of DES needs to consult with other entities about really big issues? Do you think that other departments are sufficient, or do you think there could be nonprofits or activist organizations or local farmers or whatever that needs to be consulted as well? Do you think that this is sufficient language?
I do. Thank you, Mr. Chair. I do, because another step in this process, right, is that there would be public information sessions held in the host community. And I think that the third-party report that would be contracted, I think, is a huge benefit, because right now the host community can have these kind of public hearing sessions, but they may not have the resources to pay for any comprehensive survey on their own behalf, right? They're usually operating well behind the applicant, right, who has paid somebody to put together a report arguing for the benefit. So as I see it, that report, which is available to the host community as it carries out its public information session, serves some of that purpose. And in terms of the review process here for net public benefits, I think this provides DES the additional expertise they need.
Any other comments?
Just
Questions?
one comment is, I think, we're not putting more financial burden on a potential host community by this process here, which is important, because local communities just don't have the resources.
I do have a comment/question, and I'm assuming that the department would have to create a whole set of rules regarding how net benefit would be evaluated. And it also does look like we're bringing in other departments in here in terms of the evaluation process. Do you think, as a practical matter, it's going to be possible to create a system of evaluation that's clear enough that somebody who wanted to potentially site a landfill would be able to look at this and say, okay, we've got a good chance going in to go forward, as opposed to we're going to spend this time and effort and this could be shot down in so many different places because of the vagary of the process, that would have a chilling effect on maybe creating something that could be needed in the future?
Thank you for the question. I don't see it as something that would, sort of make it look like the deck was stacked against an applicant. It seems to me that, just looking at it and working with the sponsor, that, it would basically it makes it clear that there are additional considerations that we don't normally really consider in our application process, review process, that we would now be empowered and in fact directed to consider. And yeah, I think we would very likely establish some rules that would give at least some basic guidelines. So with respect to the content of an application, maybe some additional information about these other potential impacts that would allow the applicant to make its arguments about what the extent of those impacts are and how they are, presumably the applicant would argue that they were outweighed by the benefits that the facility provided. And then that, combined with this third-party contractor evaluation, would give everybody an opportunity to provide the input that they think is appropriate for the department to consider. So I don't know if I've answered your question.
No, I think that does. May I ask one other question, please? I like this actually in principle in terms of what we're trying to do here. I do think it makes sense to look at this from a holistic standpoint. Has anybody looked into whether this has been done in other places and how it's working?
Thank you. I also would like to add real quickly that in terms of trying to not have this process appear as if it's intended to just stop landfills, that's also why we've expanded what could be considered under potential benefits. Because as the director pointed out, one concern they've heard from applicants in the past is that they don't believe that potential benefit is defined broadly enough, right? So hopefully that also, the intention is to make it more balanced. I'm not aware of, there are lots of states, I know Representative Potenza has done a lot of work on this. A lot of states have a two-stage. In fact, we're, to some extent, I think, an exception in not having some form of two-stage process where there is some preliminary set of requirements that have to be met. And I think that varies from state to state, but I know Representative Potenza has done a lot of research into that.
Yeah, so most, in regards with landfill permits, most have either a two-stage or a three-stage process or phase process. So, which can eliminate like a, like a bad location or whatever right off the bat. So, in a sense, the person's not putting in the time, or the company's not putting in the time, the energy, and effort in that. The ones that have a one phase, there's only one other one that I found, but it's really not a one phase. It's like phases within the one. So, and I think that was like Vermont, but you can't even cite a landfill right now in Vermont at all. So, this in a sense helps because these are the types of things that you would be looking at as well. Cost net benefit analysis has been going on for decades. So it's something that's very standard in the country, and that we should be doing that. Now, I put in a bill last term for a two-phase, and I didn't renew that one, but we've got this now, and maybe that's something that we think about in 2026, because it's really helpful in that sense. Because if you make it through the first phase, that gives a good kind of thumbs up to whoever's looking to move forward. That you've checked all the boxes first, location-wise, all of that kind of stuff, benefit analysis, and all of that. So.
Thank you.
And if I could, just the very last section, G, starting page 2, lines 11 to 16, that just formally spells out the stages and like how this is a two-stage process. So the department shall issue its determination of whether the proposed facility provides a net public benefit prior to completing a full technical review of the application. If the department determines that the facility does provide the net public benefit, it shall notify the applicant in writing, etc. If the department determines that the proposed facility does not provide a net public benefit, it shall issue a written denial of the application. So that just very clearly spells out if a net benefit has been determined to exist, it moves forward to technical review. If it has not been determined to exist, then the department will issue a denial.
One other question. So I think the law as it's being proposed does not have an appeal process. It's if the DES finds it's bad at step 1, it's done, correct?
Yes.
Do you feel there should be any sort of appeal process?
I mean, I would defer. I'd be interested to hear what the director thinks here. I mean, I think that the department will be, I have no doubt the department will be extremely diligent. They're well aware of the likelihood of litigation, which they certainly would be not interested in being caught up in. So I have confidence that they would approach the review in a way that would minimize the risk of litigation. But the question of appeals is not one that we've discussed, so I defer to the director.
Yeah, again, unhindered by legal training. My understanding is that the law is relatively clear that whenever the department makes a decision, it is appealable to the Waste Management Council. That's in the statute. So I think that this first stage decision on net public benefit would be categorized, my sense would be categorized as a department decision and as such, the applicant or another aggrieved party would have the opportunity to appeal the department's decision on this.
Okay, so the appeal process is baked into the code already, just not right here in this bill.
That's my uneducated assessment, yes.
Okay, I just would be interested in knowing whether this language would in effect negate the prior language of the appeals process that exists. So that would be the only thing I'd like to see, that we make sure that the rights of the applicant, are not unknowingly taken away.
Yeah, I'm sorry. Yeah, I mean, we can verify that when we bring this to the executive session, make sure we have that. But.
Yeah, and I just wanted to follow up on that. The rules piece of that is never in any of the bills that I've seen. So it shouldn't negate it, because if that's something that's in rules versus in a statute, then this wouldn't negate that, if you know what I'm saying.
See, I always thought statute trumped rules. So if we said they can't, you're done, that would negate the existing rules.
If I may, the law relative to the council establishes that the council has the role of hearing appeals of any department decisions. That's baked into the statute. So that's why what I would envision is that the written denial or approval that the department is instructed to write after it makes this first stage decision would look a lot like an approval or a denial letter that we write right now. And at the very last paragraph of that says, if you are appealed, or if you're aggrieved by this decision, you may appeal to the council within the next number of days.
Yeah, I was just going to say that when the denial letter comes from you, it says that on there. So that's why it doesn't need to necessarily be here.
Okay, thanks.
Can I ask one question about, so what was left, when OLS did the amendment, you had them do a full rewrite, right?
There was a confusion. I explained to them that we were only replacing the first section of the bill, and the next two sections were to remain untouched. What they sent us back it didn't include the next two sections, which have to do with the only one facility and defining capacity needs. So that needs to be added back by OLS.
Okay, all right, that sounds good.
Okay, we do need to wrap things up here. We have one more bill to look at. I would say as far as this bill is concerned, and your amendment, thank you for doing all the work you've done with the amendment. Sounds like you do need to contact OLS to add some stuff back in. Representative Potenza, you came a little late to this amendment where Representative Germano was going through it, so I would just recommend reading that on your own time. If you have any questions or comments, direct them to Rep. Germano later. And then what we'll do is, I think we're all pretty happy, at least for whoever supports the bill, pretty happy with the process. We don't need to discuss this bill again in another solid waste subcommittee meeting. It can just go to the executive session with the finalized amendment. Are you happy with that idea?
Yes, thank you.
Okay, so if that's the case, then we'll go ahead and we'll close the discussion on HB215, and we'll move on to looks like HB566 right now.
Okay, thank you, Mr. Chair. And so this should be a fully worked out amendment based on, again, feedback from the director, conversations he and I had. I also had some conversations with the operations director at the turnkey facility in Rochester to get a better sense of exactly how leachate management currently works. And then we talked about it a little bit in one of our committee sessions. And so what you can see here is the bill is really divided in two. When I showed it to the committee for visual purposes, I split it into two paragraphs. The first part, which is lines 5 through about 12, that has to do with a plan. When you're applying for a permit, there are components that are required to be part of that plan, right? A detailed plan, this is at line 7, for leachate management that provides for safe and effective management of leachate throughout the entire life of the facility, including the post-closure period. The leachate management plan shall include at minimum a description of how leachate will be collected, stored on site, how it will be transported off-site, the location and type of disposal processing, a statement of projected frequency of leachate transports per week, and contingency plans for capacity constraints. The management plan shall also include details of contractual arrangements between the applicant and all entities that will be engaged in the transport and the processing of leachate. And I think that's important because, as the director testified, right now the companies who operate these facilities have to demonstrate that they have contracts, but they're not required to provide specific details about those contracts. And this amended version of the bill would require that. The contractual arrangements shall demonstrate that the expected daily production of leachate can and will be transported off-site in a manner that will minimize the possibility of on-site contamination. And it goes on from there. So it's actually about line 14. The top part is about what they have to have in the plan. And then from 14 to 20 deal with what the contracts have to be able to demonstrate. Right? So when you're putting in an application for a landfill permit, you have to have this plan which shows that you have prepared for the long-term leachate management, on-site transportation disposal for the lifetime of the facility and for the post-closure period. And then kind of the second half, starting at line 14, says the contracts must contain certain details. And what this amendment does is it moved some things that were originally in that contract piece. It moved them up into the top section because we can't require contracts to last 20 years, right? We can't require certain kinds of contractual arrangements. Instead, what we do is we say, if you end up with a different contract than the one you're currently operating under, you have to provide details of the new contract to the department. But so all of the original material is here. As I said, some was just moved into the plan because legally it couldn't be in the contract section.
Thank you, Representative Germano. I had a couple questions. I understand that already in New Hampshire, some of the leachate is being treated on site, and I don't see the word treatment here at all. That may be something you may want to consider including. For example, on line 10, stored on site, how it will be transported off-site, location and type of perhaps treatment and disposal processing, because some of them are doing osmosis prior to removal, so they're actually treating on site. The other suggestion to consider is on line 16, the possibility of on-site contamination. It should be on-site and off-site contamination. So if there's no treatment and it goes to a treatment plant without proper treatment, you'll have off-site contamination too. So I think the question of treatment may be one to be included both on and then the issue of on-site and off-site contamination, like both relevant. Any thoughts on that?
Yes, I like the idea of referring to somewhere around from 9 or 8 down, right? The leachate management plan shall include at minimum a description of how the leachate will be collected and stored on site. Perhaps there's a phrase that can be put on there, put at that point to the extent of and any on-site treatment plans, because that's what they do at Rochester.
They're doing that right now,
yeah. So I can see putting that in there. And then where was your suggestion around the off-site?
Line 16, the possibility of on-site and off-site contamination, because contamination could take place off-site if not managed properly. For example, without the pre-treatment with the facility, a wastewater plant that doesn't remove the PFAS, things like that.
Well, that is something perhaps we could ask the director's views on. What I don't know is if it's the operator, if the operator's responsibility. So let's say you have a contract with somebody to transport the leachate off-site. It depends on the details of the contract, I suppose, but it wouldn't be the facility operator who would be responsible for an off-site spill. It would be whoever is contracted to provide that service, correct?
I suppose that would depend on the details of the event, but my understanding is that perhaps, and maybe I'm misunderstanding, but I thought perhaps the representative was asking about possibility of a release happening on the site and that resulting also in off-site contamination.
Yes, either way.
Is that right?
Yeah.
Well, I mean, what I think that makes it a little bit confusing is this section of the bill is referenced to transportation, not a spill that occurs on site and then goes off site.
Okay. So this is a check.
I mean, I believe we already have rules that deal with that scenario, right? If we have an on-site leachate.
Oh, sure. Yeah, there are extensive rules about requiring how leachate is collected and transported and transferred to transportation vehicles and then transported off-site.
Yeah, and we also have, there's extensive information if there is, with what needs to happen with reporting when there is a breach or a leak or anything.
That's correct.
All right.
Regardless of where the leachate is released, if there's a leachate release, there are reporting and response requirements
Correct.
associated with that.
All right, I have a suggested amendment for language for you, which I can give to you, but regarding the issue of treatment on site and or just, transportation and treatment off site, we could in line 9 say how leachate will be collected and stored and treated on site and or how it will be treated off site for disposal and location. So I think I'll give you a copy of this. You can decide if that language works for you. The other issue or question I have, so we're basically having the applicant demonstrate that they found a company that can treat this leachate and that they're going to go into a contractual arrangement with them. I would also, I hate to think the idea that they've tied their tail to just one place and that the stuff is going to be generating continually, and if some reason their contracted company has problems or shuts down, then now we've got a real problem. So it would be nice if we could ask them to certainly demonstrate that they get into a contractual relationship with one and that there are alternatives currently available that they can quickly switch to in case something shuts down and suddenly we've got a problem.
Yeah, my understanding, and perhaps the director can speak to this, when I spoke to the folks at Rochester, is that is the practice and that will be in the plan. So they have a current contract with someone and they have contingency plans so that if the person with whom they've contracted all of a sudden doesn't have disposal capacity, that there is a secondary, and as I understand it, even a tertiary plan for contingencies.
The current rules require that each facility have at least 2 contracted outlets for their leachate, and in practice, we're aware that most facilities have actually more than 2 identified, but they're required at minimum to have a contractual arrangement with at least 2 facilities.
Okay, so basically the current rules, so we don't need to add that language into this.
I think it's an excellent question. I would only do it if the director felt it strengthened the department's work. Because as the director's pointed out before, there is overlap between this bill and existing rules, but we've written it in a way that the department feels it strengthens what they're able to do. So if that was something that the director felt would be of use to DES, I wouldn't be opposed to it at all. If he doesn't think it's necessary, then I would defer to his judgment.
Okay, just so we all know, we need to wrap it up here really quickly. Representative Potenzi, you have one more question?
Yeah, so it's for Representative Jabrona as well as Mr. Wimsatt. I think the point is taken because there are, so where it says a statement of how, where is it? Okay, here it is. How leachate will be collected and stored on site.
Which line do you want, please?
It's line 9 to 10. Will be collected and stored on site because there are some locations that might do treatment on site. So I think that it makes sense to add that in just because of that. And it could basically be, treatment on site in parentheses if, you know, if applicable, because of some people don't, of course, or some places don't. And then it can continue on, how it will be transported off site for treatment, whatever. I agree. I think that you could put that in there just because it would apply for anyone that is treating it on site. That wouldn't hurt anything, right?
No, I don't believe so.
Okay.
Okay, so it sounds like there's been some interesting questions brought up about this, and it sounds like this one needs maybe a little bit more work, Representative Germana, than the others. And I'm wondering, I mean, this is an FN bill, so it needs to be acted on fairly quickly. And I'm wondering if maybe whatever work you do on the amendment, maybe we should have one more quick solid waste committee meeting before it gets presented to executive session, or do you feel confident that maybe you can be in discussion with Representatives Potenza, Scully, and Gruber about the tweaks you need to make, and then it can just go straight to executive session? What are your thoughts on that?
Well, I think we should talk to the chair and the ranking member about the timeline. My sense is that we may not have time for another subcommittee meeting before we have to report this out. So I think we should just have a discussion with the chair and the ranking member. If we have the time, then I think it makes sense to have another meeting to discuss it. If we do not, it sounds like we've got consensus over the changes that we want. And so I could have those changes made, circulate it, and we could agree among ourselves prior to the executive session next week.
Okay, so you think we can avoid another solid waste subcommittee meeting?
I do. It sounds like we've got good consensus about changes that we would agree on.
Yeah, it's very good.
Okay, good. I'm happy to hear that. If that's the case, then we've discussed all three bills that were on our docket today, and I'll entertain a motion to adjourn our meeting.
So moved.
Second.
Okay. All in favor? Aye.
Aye.
Motion. Meeting adjourned.